SJC-11744, Michael A. Vale v. New England Cleaning Services, Inc.
Good morning.
Good morning, Mr. Chief Justice, Associate Justices. May it please the Court, my name is Euripides Dalmaneris, and with me is James Bucking, and we represent New England Cleaning Services, Inc., the appellant, also known as NECS. Article 5 of NECS's Articles of Organization contains a customary stock transfer restriction, which is essentially identical to the corporate article that was the subject of this Court's decision in Merriam v. Demula Supermarkets.
Can I just interrupt you right there? Looking at it in terms of the arbitration as a sort of contract proposition, it's very clear that if the person who wants to sell his shares says, I'm offering my shares for $1 million, and the company or the directors accept that, that's an offer and acceptance, and it's right there.
Correct.
Are you saying that you have the same event happening, or the equivalent of the same equivalent, when offers made and the directors say, no, but here's who we're picking as an arbitrator? That's exactly the same as an offer and acceptance?
It is not exactly the same because there's no commitment by the company to acquire the stock. However, once the election is made. So
all right. So in that way, it's unequal. One side has got all the cards because as you just said, that the company doesn't have an obligation to buy. But I take it your position, this is apart from the arbitration, but I take it your position is the company may not have an obligation to buy, but once the stockholder makes the proffer and the company says, no, but here's my arbitrator, he is bound forever. He has to sell if the company accepts it.
Correct. And the stockholder holds all the cards at the beginning because he or she gets to determine whether to invoke the article and offer to sell his stock. And in this case, the appellant
cannot change his mind at any point once he does it.
He cannot change his mind, and he agreed when he signed, in this case, Mr. Vale, when he signed the Articles of Organization as a founding stockholder, he bound the company to this process. And then when he accepted his stock, subject to the restriction, and Article 5 is written on his stock certificate, he agreed to follow the process as a stockholder. In other words, he gave advance written binding consent to arbitrate the value of the stock if that was the option that the company elected.
Yeah, I get all that, but not just to arbitrate. He can't change his mind at any point once he says, here's my offer.
That's correct, and that's what the language of the article states.
Yeah, where does it state that one may not revoke an offer?
Yeah.
Your Honor, it doesn't state that he may not revoke an offer. It doesn't state that he may revoke an offer. And what we have here is an enforceable contract. We got corporate articles that bind the company and the stockholders. As the court held in Chokel and in Merriam.
No one disputes that it does. The question is, where does it so state that once an offer is made, it may not be revoked.
Your Honor, the article does not have that language, and we submit it doesn't need it, because what we have here is an enforceable contract. Enforceable binding contracts don't require provision that state that a party may revoke. It is presumed in the law.
Counsel, does
I'm sorry, he's
does
not,
the
the issue is not whether he's revoking the articles, the agreement to enter into the articles. The issue is whether or not he may revoke the offer to sell.
Yeah.
But the offer is made pursuant to a specific article. We're not dealing with a situation where we have two parties who haven't had prior dealings with each other.
No, I know that, but the article doesn't talk about what happens if the shareholder wants to change his mind. Doesn't talk about it.
Because the shareholder doesn't have that prerogative once the company makes its election. The article states that once the company makes the election to arbitrate, the two arbitrators shall appoint a third, and then the three arbitrators shall ascertain the value of the stock via arbitration.
I apologize to my colleagues. I just wanted to ask if the statute, once you initiate the arbitration process, does that provide the binding that you're referring to? Does that have anything to do with the offeror's right to revoke his offer?
Well, certainly under Section 1 of the Massachusetts Arbitration Act, the arbitration clause in the articles is presumptively irrevocable unless it can be revoked for some grounds for revoking contracts generally. And there is no argument in this case that the arbitration clause would be revocable for purposes of public policy or unconscionability. And even if one were to take the view that this was not an arbitration clause, as the Superior Court held, it was an appraisal clause. Appraisal clauses were irrevocable even in the 19th century as a matter of law. So the clause here, the arbitration clause, is irrevocable under statute and pursuant to the common law.
Now, if we find that it is ambiguous as to this issue of whether there is, whether the offeror may revoke before acceptance by the corporation of the arbitrated or appraised price, do we interpret the ambiguity against the drafter, that is the corporation?
No, because here, Mr. Vale was a founder of the company. He was its original president in 1977. He signed the corporate articles as an incorporator and then received his stock certificate as a stockholder. So, one, I do not believe that it's ambiguous. But two, if there were any ambiguity, it should not be held against the company. Yes?
Okay, I'm moving on to another issue. Sure. What significance, I take it you say it has none, but I'm not entirely sure why, that late in the game you've discovered two more directors, right?
Well, according to the appellee, Mr. Vale, there are only two bona fide directors on this company.
Well, that's what he said, and that was your view, but your view has changed, right?
Our view has changed, but his view hasn't changed.
Well, let's talk about your view.
Sure.
How does that affect this? Let's assume he accepts that view, that there are now four.
I don't think it changes the analysis at all. The company,
well, does it change, not the analysis of what the clause means, I get
Sure.
that, but does it change the facts in the sense that the company actually, we don't know whether the company said no, but here's our arbitrator, because only one person decided it.
well, a majority of the disinterested directors rejected this $5 million offer from Mr. Vale.
I'm
So,
lost you.
a majority of the three directors other than Mr. Vale rejected his offer.
Did they? I didn't know that they ever voted on it. Did they?
They had a discussion and it was rejected. Now, the controversy
I thought they didn't sort of surface until much later.
Your Honor, one of the directors is the company's controller. He's been with the company since 1992.
Okay.
He was not in favor of accepting the $5 million offer.
Was
Neither
there a
was
formal
Mr.
meeting and they voted?
There was not a formal meeting, but there was a discussion. It was rejected. And I would like to say the dispute over the composition of the board occurred in March 2014. The argument on the motion to compel arbitration was that month, and the decision on the motion to compel arbitration came in April. And the appellee never raised this issue during that period of time when he could have. So for that reason, we believe that the argument is waived. And beyond that, we don't think it makes a difference. I mean, the suggestion by the appellee that two directors that he does not believe are directors were required to vote to reject his offer, he can't have it both ways. He can't say, on the one hand, I don't believe they were directors. On the other hand, they should have voted to reject my offer. Beyond that, we're here now in January 2015. Whatever decision was made by the company in October and November of 2013 has been ratified by the other directors, and we are pursuing this appeal.
Is there a formal indication of that?
Is there a written resolution? No.
Let
Okay.
me,
But this company has been, Your Honor, this company has been run informally for 40 years. It was started by two brothers. It's a closely held corporation, family held, 50-50. They did everything informally. The corporate record book is very thin, going back to its formation.
So your position is, although Mr. Vale had previously suggested that he would sell his stock and had even named prices, but then apparently withdrew those offers, that this time, once he named an arbitrator and triggered Article 5, that was it. He could not take the offer off the table, not take his desire to sell off the table, no matter what.
That is correct. Otherwise, if he has that right, one, he could exercise it in theory at any point during the Article 5 process.
So what if,
Sure.
on a prior offer, the board had said, no, but we're not going to accept that offer, or simply said, in response, we're naming an arbitrator? Would that have triggered this binding process as well? Or is it the fact that Vale said, I'm naming an arbitrator, that triggered this?
Well, the fact that he specifically invoked Article 5 in his notice of October 2013 formally began this process. Now, Mr. Vale filed this lawsuit early in July 2013. Several weeks later, he submitted an affidavit in the Superior Court where he stated under oath that he's agreed in principle to sell his stock provided that he is paid a fair price. That is in the record. It was in the record below. After he filed that affidavit, the company asserted a counterclaim against him seeking his specific performance of Article 5, because we took the position, well, if you want to sell your stock and you want a fair price, you have to abide by the corporate article that you agreed to follow when you signed the Articles of Organization and accepted your stock. The company asserted that counterclaim in the litigation, and within 6 weeks, Mr. Vale, acting with the advice of counsel, sent a letter to the board specifically invoking Article 5 and in a notice that set his price and also named an arbitrator, Mr. Penrod. And the notice also said that the company had 30 days to either elect to acquire the stock at his price or to name an arbitrator, and the company timely named an arbitrator.
here's my concern, okay? Let's imagine another corporation. Take this company out of it with exactly the same articles as yours. If there is no power to revoke, once a shareholder seeks to sell, the corporation could take actions which would markedly diminish the value of the corporation for the purpose of lowering that price. And if the individual does not have the ability to revoke the offer, they're compelled to accept an artificially low price for their stock.
Your Honor, the company is bound by the covenant of good faith and fair dealing to fulfill its obligations under the corporate articles. And just dealing with that hypothetical, if there was any evidence that the company would do something like that, Mr. Vale would have recourse, either in court or perhaps also in front of the arbitrators, insofar that there was an artificial deflation coincident with the invocation of the article. In other words, and this comes off...
The arbitration, if it is an arbitration, is solely to determine fair market value. It's not to make other findings, is it?
No, I understand, but in determining fair market value, you're going to look at the past performance of the company, an evaluation expert will, also look at management's projections, current performance, and try to project out.
Right, but if management says we're not going to give any dividends, wouldn't that reduce its fair market value of the stock?
Well, depending on what economic factors the company is facing, it may or may not.
All right, thank you.
So a simple offer to sell doesn't trigger Article 5?
A simple offer to sell violates Article 5.
Why?
Because the offer to sell has to be in accordance with Article 5.
So an offer to sell, and he's made other offers to sell, we're in violation of Article 5.
Correct, and that's why the company brought a counterclaim to compel his performance with Article 5.
Okay.
Thank you.
Good morning, Justices. May it please the Court, Robert Berluti for Michael Vale. Picking up where we just left off, if Michael Vale violated Article 5, then the other shareholder, his brother, Valchuis, also violated Article 5 because he had been getting him, Mr. Vale, to try to sell his shares since 2005. The parties had had discussions. They had never reached agreement. What Article 5 is a stock restriction. Mr. Vale never tried to sell his stock to anyone other than the inside group, which was his brother, or if the corporation decided to buy it, the corporation. What this appeal seeks to do is to transform a stock restriction provision that is a shield to prevent a transfer to unacceptable parties into a sword to compel a shareholder to sell his shares in a closed corporation when he no longer wishes to sell his shares.
But wouldn't you agree, which isn't quite what Judge Desmond found, but it does seem to me that in order to sell his shares, unless there is an agreement on the price, there has to be an arbitration as to what is the fair market value.
Not an arbitration. What there is a restriction. In order for him to sell his shares, he has to clear the restrictions, and that would be an appraisal by everybody naming their appraisers and the third. So that's what would have to happen. The restrictions would have to be cleared unless they were waived because it was being bought by the brother or by the corporation. There'd be no reason to have that.
You're calling it a restriction, but the language in Article 5 refers repeatedly to arbitration.
I'm glad you brought up that point, Justice Hines.
Really?
The very title of the section, the very title in the Articles of Organizations, number 5, is restrictions, if any, that apply to the stocks. That's the title of Article 5 in the Articles of Organization. Secondly, there's no question, they've counted them. The word arbitrator appears, I guess, 7 times. The word arbitration never appears anywhere in the section. They simply use the term arbitrator.
So
and whether
what process is an arbitrator involved in if it's not arbitration?
Well, in this instance, it's not. It's not required to hold a hearing. It's not required to take evidence.
Is that required in any arbitration? I mean, we have informal arbitrations in Massachusetts, right?
Well, I think the case law is quite clear that there's a difference between an appraisal.
But articles of when you see an arbitration clause that even you would call an arbitration clause in a contract, it doesn't lay out, and the arbitrators will hear evidence, and they will do this and that and the other thing. It just says they're going to arbitrate whatever the issues are.
Well, most of them that I've seen do call for a set of rules, whether it's JAMS, whether it's AAA. But that aside, I'm not saying that alone is what triggers it. The point of an arbitration, and what the cases have found, is that you have to resolve a dispute. Whereas in an appraisal provision, all you're trying to do is ascertain a value.
No, but there is a dispute because, I mean, by definition, there's a dispute because somebody has offered to sell shares for X amount of money. And there's a dispute as to whether the company wants to pay X amount of money, right?
That's not a dispute, respectfully. The company doesn't elect to buy at that price, that's true. And if the seller still desires to sell, which is the condition prerequisite to this whole provision, then he has to clear the restrictions. But at the end of the day, there's never an obligation to buy.
But once he clears the restriction and a price is set by the arbitrators, isn't he free to sell to anybody?
Yes, but at any price. He's free to sell. The restrictions are then cleared. That's right. That's the only significance. There's no dispute resolved. He's then free to sell, but he can sell at any price. He's not free to sell at that price. He's just free to sell at any price. The restrictions are cleared.
What's the difference if you I mean, it seems to me that the question here is whether or not you can revoke as an offeror. Does it matter then, if you assume for the sake of argument that you're not required to go, that you can revoke as an offeror, does it matter then whether it's an appraisal process or an arbitration?
Well,
if you regard this as a stock restriction provision, as you've suggested.
yes.
And somebody triggers Article 5 and says, I want to get this going, and I'll appoint, I'll name my arbitrator, you name yours, name a third. Does it matter whether you consider that an appraisal process that will go on or an arbitration process? Because whoever it is going to resolve whether you consider it a dispute or they certainly disagree on what the value of the stock is. They'll settle that. The appraisal process would settle that, and the arbitration process would settle that, right? So does it matter then what you call it?
Well, I think it does. I think that in this instance, the prerequisite to the whole provision is when a shareholder desires to sell.
Right.
When that desire comes away, he should be able to revoke it. In this instance, all that happens is that these appraisers, arbitrators, whatever you call them, they're all the same thing, ascertains a value. But they ascertain a value only to see if the corporation then wants to purchase the stock at that price. They're not obligated to do that. And all that happens is that the restrictions at that point then go away. All that happens if he withdraws, all that happens if he revokes is that the restrictions remain on the stock, which he's never challenged. That's absolutely the case. No one's challenging that the restrictions remain on the stock. That's the intention of this provision, and that's the status quo.
I'm sorry.
Go ahead.
Go ahead.
Okay, I will then. If a process were to come out with, suppose the process were to go forward and the appraiser were to or the appraiser or the arbitrator, the process ended with a determination that the fair market value was $4 million. So what happens then? The company then has the right to buy it at $4 million?
Yes.
But you have the right, before the company actually says that, you have the right to say, I don't want to do this anymore.
I think that's right.
Is there any possibility that even if you have the opportunity to revoke, in theory, there's a reliance interest once who's paying for this appraisal?
Well, nothing had happened. In this particular instance...
Well, I know here you got out early, but
right.
Let's assume you had gone through the full process, as Justice Lenk describes. Money had been spent to conduct evaluation. They say $4 million. You say, I don't want to sell at that price. I revoke the offer. Can they say, wait, you just cost us $50,000 to bring in these arbitrators and conduct this valuation? You can't revoke now. You have a reliance interest.
Well, first of all, it would be paid by the corporation, of which the shareholders would each be bearing their pro rata share of it. But I don't think there'd be a reliance interest at that point because of the language in this specific restriction. And the language, it starts out at the top. It's a condition. If a shareholder desires to sell. What's being attempted here is to convert a restriction into an obligation to sell. And I think that would violate this court's ruling in Brody versus Jordan. What is undisputed on this record is that there is no purchase and sale agreement. There is no buy-sell agreement. There is no agreement between the parties obligating anybody to sell their stock.
So what if, I mean, I'm looking at how Article 5 is drafted. It says, after the report of the arbitrators as to the value, the directors shall have 30 days within which to purchase. Are you saying that doesn't mean the directors have the right to purchase?
They do have the right to purchase. I think they do have the right to purchase. I think that...
Your client has the obligation to sell? If they have the right to purchase, does your client have the obligation to sell?
If he continued to desire to sell, the answer is yes.
Is there a limit? I mean, there was a motion to compel you to arbitrate, but is there, okay, let's say you're correct and you have the right to revoke this. The argument that they make is you'll just keep doing this until you finally get somebody to appraise it at a value that you find acceptable, or they give up and say, whatever you want, just get out of my life. So at some point, are they entitled to say, you are acting in bad faith, you're violating your fiduciary duty, you're making us go through this rigmarole again and again and again, and compel you, as they wish to do right now?
Well, that's a loaded hypothetical, because in this particular instance, the gravamen of the case is that of a corporate freeze-out. So Mr. Vale has strong feelings that the suspension of a 36-year history of dividends, increasing the salary of the shareholder that remains, and whatnot, is really what the freeze-out is, and this is just to complete the freeze-out. And by not allowing him to revoke would actually have him...
Wait a second. You started this, though.
We started the...
You started it. You made the offer and appointed an arbitrator.
We did. At one point, Mr. Vale thought that maybe the best way to get out would be just to sell, but he changed his mind.
Yeah, but
the thing that really triggered it was the suspension of dividends. He also started the lawsuit.
Yeah, well, I mean, that seems to be the remedy for that. But once is a lawsuit saying you've been frozen out and you have certain rights under those obligations, fiduciary obligations, et cetera. But to then start the process and then stop it, seems to me once you started it, maybe you are bound by it.
Well, Justice Cordy, I understand your concern. The point is, I think you also have to look at the reality of this. You're getting discovery all the way. You're learning things about the corporation. One of the things that had been alleged was that sales were going down and that there were going to be increases in labor costs because of union negotiations. As we saw the monthly financial statements come through, we saw that that wasn't the case at all. The sales never decreased. Labor costs never increased. We think that you can't convert a restriction agreement into an arbitration agreement.
But it is an agreement, and why shouldn't contract principles apply here, at least with respect to an implied condition that once you've made the offer to sell and the price has been determined, that offer to sell has to be on the table for a reasonable period of time?
Well, what was the agreement? That's the question. The agreement is that there'll be restrictions on the stock. That was the agreement. No one's saying that those restrictions don't remain. Just because there's a sense at one point that they may want to sell and begin this process, they shouldn't ever be required to compel them to sell. That's not what the agreement was.
So you don't think that the offer should be, you don't think that your client should be bound to keep his offer on the table for a reasonable period of time after the valuation has been made?
That's right. Well the valuation wasn't made. The valuation wasn't made. The valuation never got that far. The two arbitrators never even picked a third. They never even met to even discuss picking a third. So those are just not the facts.
What if there were a valuation by the arbitrators? Would the offer have to stay on the table for a reasonable period of time?
That's a closer question, and Justice Gantz really went to that earlier, and I think that's a closer question, quite honestly. But I think that just reading the provision says as a prerequisite, if a shareholder desires to sell. It seems to me if his desire to sell changes at any point, he should be able to end the process. That's not even a close call in this particular case where he did it before they even selected a third appraiser.
I've not looked at the complaint, but your brother tells me that you're seeking an accounting?
Well, the amended complaint ultimately seeks as a part of the remedy in accounting, yes, Judge.
And is that an end run from this appraisal process? Because you're asking...
No, that's for purposes of excess compensation and for payment of dividends.
Okay, so that's not, the accounting is not for the purpose of you selling at that price?
No, not at all. There's nothing part of that, no.
Ordinarily, I mean, you've got an arbitration clause that essentially says if disputes arise, they're subject to arbitration. And so the person who's complaining, obviously, has to proceed through the arbitration process, but the person who's complaining can always withdraw their complaint, say, I'm not complaining anymore. Why isn't that the case here? I offered, but now I'm not offering anymore. So I don't have to pursue the process. You would say yes?
I would say yes. He doesn't have to continue on. If you don't have a complaint, you don't have to do it.
Justice Hyde, you didn't get a chance to ask your question. Are you satisfied?
I am, thank you.
Then thank you.
Thank you, Justice.